Hello, good afternoon.
Hello, good afternoon, everyone. I'll just give everyone like 2, 3 minutes to see how many people will still join. Then we'll kickstart the webinar. Please. Good afternoon and welcome to today's webinar. It's my pleasure to see such a distinguished gathering of brilliant minds and enthusiastic people gathered here to dive into this very critical issue. I welcome you all to this webinar on arbitration across borders, comparative analysis of procedures and enforcement. On behalf of the YMG Nigeria branch, I thank you all for taking time to join us for what promises to be a very engaging, insightful, and intellectually rewarding session. In an increasing globalized world, commercial and investment relationships now transcend national boundaries more than ever before. With this growth comes complex cross-border disputes and that demands efficient, neutral, and enforceable dispute resolution mechanism. Arbitration has therefore emerged as a more preferred and strategic tool for resolving such disputes, particularly across different legal systems and jurisdictions. Today's webinar is designed to explore the practical, procedural, and enforcement challenges of cross-border arbitration, while also highlighting emerging opportunities, comparative perspective, and best practices from different jurisdictions. Our discussion will shed light on how practitioners, especially the young professionals, can better navigate arbitration in an international context. We are privileged today to have distinguished speakers who bring a wealth of experience in international arbitration, cross-border dispute resolution, and comparative legal practice. We have confidence that their insights will deepen our understanding and contribute meaningfully to professional development and capacity building for us. So today, I will encourage everyone to actively engage, ask questions, and take full advantage of the learning opportunities this webinar offers. Once again, thank you for joining us, and I wish you all a productive and enriching session. Please, before I hand over to the moderator, I would like to invite the branch chair of CIAB Nigerian branch, Mrs. Olushola Adebomire, to give her opening remarks. While we wait for her, I would like to also inform us that for those from Nigeria, after the O program, attendance is going to be noted and sent to MBA. So you don't need to put in your Supreme Court number in the chat box. We'll definitely send the attendance to MBA after the event. I don't know if the branch chair is on the online. So can you all hear me?
Yes, you can be heard.
Oh, okay. I don't know if she's online. While we wait for her, I would like to introduce the moderator, Chizaram Mba. To take the lead to continue the events.
Hello, everyone. Good afternoon. Thank you very much to the YMG chair. Can I be heard?
Yes, you can.
Okay. Great. Thank you. Thank you very much to our YMG chair for the introduction. And thank you, everyone, for joining this session. So as the theme suggests, our discussion today will highlight the cross-border differences in the practice of arbitration and the enforcement of awards. We focus on 4 key African jurisdictions: Nigeria, Uganda, Kenya, and Ghana. Our aim is that you leave this session with practical insights into how arbitration plays out across this jurisdiction, that we can compare notes, compare experiences, and learn from one another's approaches, what can be applied in our respective jurisdictions. I'm joined by an excellent panel of speakers, each representing the jurisdictions that I have just mentioned, and they will bring in distinct perspective to the discussions. Permit me to just briefly introduce them. They are Dr. Chikwendu Madumere. He is the co-founder of Madumere and Madumere and the deputy chairman of the SIAB Board of Trustees, Nigeria. Mr. James Ngotho Kariuki from Kenya, the treasurer of the SIAB Kenya branch and director at ADR Center Limited, Kenya. Mr. Jeffrey Kadu from Uganda, an associate at AF Mpanga Advocates. And last but not the least, Mr. Isaac Aburom Lati, senior associate at Sam Okuzeto and Associates. I hope I'm pronouncing the names correctly. Please feel free to follow them on LinkedIn if you want to have more information about their profile, their bio. In terms of the modalities for this session, I'll direct initial questions on specific issues to certain speakers who will address the questions, and then there will be follow-up prompts to other speakers to draw out their comparative perspectives on that issue. If you have any questions, please feel free to drop your questions on the chat, and we will have a 10-minute Q&A session after the discussions, and we will take the session. And if we also have time, you can show, just raise your hands, your virtual hands, and we'll also take your questions if there is still time. With that, let's get started. So our first question concerns a fundamental aspect of arbitration procedure, which is the commencement of arbitration. And I'll start with Mr. Kadu from Uganda. You're a practitioner based in Uganda. I would like you to tell us what are the key procedural steps and requirements for commencing arbitration in Uganda that parties must strictly comply with.
Hello, good afternoon. I hope everybody can hear me.
Can hear you, yes.
Yes, we can.
My name is Jeffrey Kadu. As I've been introduced, I work with AF Mpanga Advocates in Uganda. Now, the case for Uganda is very much similar to that across Africa, because at least for the existence of an arbitration, there has to be an arbitration agreement. And the law is very clear and specific about that. Sections in the main governing law, the Arbitration and Conciliation Act, are very specific that without an agreement, we cannot arbitrate. So that is already the starting point. Now, practically, when the arbitration has or is about to be commenced, the court always considers, or there is a consideration for preliminary matters, particularly when you're dealing with multi-tiered clauses. Very many times, arbitration clauses require that parties first undertake some sort of ADR, mediation or conciliatory processes, before you can proceed to court. Now, the courts have been very strict on applying this requirement, and the Attorney General filed an application in 2024 on particularly trying to challenge an arbitration process on the basis that they had not gone through the preliminary steps of conciliation. Unfortunately, in a case called Networth Consults versus Attorney General, the court found that the case could proceed with litigation because the dispute resolution clause in question provided for litigation and arbitration. And because of their involvement in the litigation process, they have waived arbitration. So the Attorney General's application failed because his conduct was read into by court as a waiver of their right to arbitrate. That is Networth Consults versus Attorney General. You can find the case online. So after there is an arbitration agreement, after we have gone through the preliminary proceedings, a party is then required under the law, Section 21 in particular of the principal legislation and Article 3 of the CADA rules. I will maybe explain a little more about CADA later. Now, these specifically require that a party serves a notice of arbitration, and the rules go ahead to tell us what is expected in a notice of arbitration. So in a notice of arbitration, you expect to find the demand, what is the actual demand, the names of the parties, the reference to the arbitration clause. So very many times lawyers copy and paste the arbitration clause depending on how long or practical it is. They expect a reference to the contract out of which this claim is arising. They also expect a general nature of that claim, the relief sought, and proposals. So now many lawyers in practice conflate this notice of arbitration with the statement of claim. Now, in Ugandan law, there is no requirement to file your notice of arbitration with the statement of claim, but if you choose to do it, there's also no penalty for not doing it. So in practice, whereas this is the list, some people also file the statement of claim. Whereas, though, it depends on a practical requirement. Now, after you have filed your statement of claim, after you have filed your notice of arbitration, and then that's when you enter the appointment requirements, which we'll talk about later. Section 10, Section 11 of the Arbitration Act give us the processes that we follow in appointing of arbitrators. And after we've appointed, then the reference can be entered, and that's when the commencement can begin. Now, you see that the difference between the arbitration is beginning after appointment. So this is when ideally you would file your statement of claim. So you see why filing your statement of claim with the notice of arbitration before an arbitrator has been appointed can be redundant, so to speak. So whereas there's no strict requirement to do it, people do it, but you can end up doing double work. So upon appointment of the arbitrator, if the parties agree, then a reference can be entered. So in practice, many of these steps are mandatory. So there has to be an agreement, it's mandatory, there has to be a commencement, and there has to be a statement of claim before the arbitration is entered. And the courts have been very strict in applying these requirements in different decisions, some of which I have presented. Yes, I hope I've answered the question.
Thank you very much for the elaborate answer, Mr. Kadu. So the next question will be to Mr. Lati from Ghana. We've heard how the practice is in Uganda. There are certain mandatory requirements, and Mr. Kadu has mentioned there must be an arbitration agreement. And if there are any pre-arbitration procedures that must be complied with, particularly where you have a multi-tiered arbitration agreement, and he has also mentioned a notice of arbitration. Now, in Ghana, would you say that your jurisdiction takes a formalistic approach to the commencement of arbitration, or is it more practical?
Sorry, I think I lost you a bit. I don't know if it's just me, but can you hear me?
Oh, yes, I'm happy to repeat my question.
Yes, exactly. I'll be grateful if you could repeat your question. But I think you were asking if Ghana takes a more practical approach
Precisely.
or a holistic approach.
Yes.
Thank you very much for this question. To start with, I would say that Ghana's legal regime concerning arbitration is also similar to that of most African jurisdictions. But just to say that, the most important thing for the commencement of an arbitration in Ghana is the existence of an arbitration agreement. Aside from, in the absence of any contrary agreements contained in the arbitration agreement itself, there are no rigid formalities as to how the arbitration needs to be commenced, right? This is subject to the respective arbitration rules that the parties have agreed on. And so you don't have a unified rules regarding how to initiate arbitral proceedings. What the ADR Act does is to provide what constitutes a valid arbitration agreement and leaves the formalities to the respective rules that the parties would select. And so in that case, there isn't any rigid notice timelines, or there isn't any rigid form as to how a demand for arbitration should look like. In terms of the form of an arbitration agreement, the Act gives a broad scope of what constitute written agreements to include simple exchanges of communication, of course, an agreement in writing signed in a contract or incorporated in a contract, or even the admission of the existence of an arbitration agreement in pleadings. Now, one of the key reasons why Ghana takes a very pragmatic approach is that under Section 27 of the ADR Act, right, that section provides that if you have any objection as to the form of an arbitration agreement, or if you have any objection to the commencement of an arbitration by a party, you need to do so timeously. If you participate in the proceedings and you don't raise this timeously at the early stages, this will prevent you from raising it at the latter stage of the proceedings. So in general, I would say that Ghana takes a more pragmatic approach. But the only aspect that will be considered as very formalistic will be the requirement of notice. Certainly, you must put the other side in notice on any arbitration initiation that you want to commence, so that if you do not give adequate notice to the other party in terms of having it served on the other side, then of course this can be raised and challenged. So that's Ghana's approach. Very pragmatic, but formalistic in respect of notice requirements.
Thank you very much. So we hear that Ghana takes a pragmatic approach, mostly pragmatic, but certain aspects must be formalistic. The next is to Dr. Madumere. I would like to know, we are both Nigerians now, and I'm sure that Nigeria also has certain key procedural requirements for commencing arbitration. But the question is, what is the implication of failing to comply with these key procedural steps? Are they fatal or are they curable?
Thank you very much, Madam Moderator. I should start by congratulating the YMG Nigeria and the chair, and of course the entire ESCO for putting this together. So kudos to all of you. Now, to the question that you asked, Madam Moderator, from the answers we have had so far, you will assume that since arbitration is a formal process, that mistakes or defects in notices could be fatal. But you will recognize that one of the beauties of arbitration, one of the attractions of arbitration, is the flexible nature of the process. Arbitration is a very flexible process that allows a tribunal to adjust the process so as to not to defeat the justice of the matter. And with regards to what the law says, if you look at the Nigerian Arbitration Act, the AMA, the Arbitration Act of 2023, if you look at the first schedule, Article 2 uses interchangeably the word shall and may. If you look at Article 2, which talks about notices, it uses may in sub 1 and sub 2, then uses shall in sub 3 and sub 4. And that tells you something, that for you as a tribunal, that allows you the flexibility to ensure that the justice of the matter is not defeated on account of very casual or insignificant defects in the way the notice is couched. And then again, if you also look at Article 3, particularly sub 5, it says that arbitration shall not be hindered by controversy regarding insufficiency of information in the notice. And that is why your standing as a tribunal comes to play, which is what sets us apart as Chartered Institute, which is why we are doing what we are doing, to ensure that the arbitrator is well trained, understands procedural sovereignty, which he has, to ensure that he drives that process in a way that is efficient and effective. Thank you very much, Madam Moderator.
Thank you very much, Dr. Madumere. So what I hear you say is that flexibility and the interest of justice is what is paramount. So there would be no fight over little issues with the notice and all that. As far as the interest of justice is protected, then the arbitration will go on. Thank you very much. We'll now be turning to another very important issue, and arguably even more important than the commencement stage, because it can have an influence on the award, which is the appointment and challenge of arbitrators. And Mr. Kariuki, our brother from Kenya, I would like to ask you, are there any limits or nuances to party autonomy in the appointment of arbitrators? And where do the courts step in?
First of all, thank you very much for this opportunity. I'm really happy to be here, and for everyone on board for sparing your time. And to answer your question, first of all, party autonomy is center to appointment of any neutral, not just within arbitration. And particularly in Kenya, this is enshrined in our law, and specifically Section 12 of our Arbitration Act, which now extends, or rather speaks to the court's power in making appointments, and in particular, the power of arbitral tribunals with respect to the extent of their authority accepting or taking up that appointment. And the Act premieres by acknowledging that party autonomy to agree on who or how to appoint the arbitral tribunal is primarily with them. And I think that's central, and that's what has been lifted from a number of general codes, such as the New York Convention and also the jurisdictional model law. However, party autonomy is usually enshrined within the agreement, and so it's lifted from whatever has already been agreed upon by the parties to said appointment. Now, when a challenge arises, in Kenya, or rather within our jurisdiction, we employ the principle of competence, which in English translates to just competence, which is the authority of the tribunal to rule on its own jurisdiction. So this is a very important step before any intervention of courts, which is enshrined within Kenyan law. And simply put, it in as much as it's ironic for the disputant or someone who's being contested to decide on their own authority, it's critical. It's a critical step because it gives parties an opportunity, as well as the tribunal, also to address any challenges with respect to their own authority within their appointments. Now, that being said, if that decision by the tribunal is not agreed upon, then what our law prescribes, it prescribes a specific amount of time, 30 days to be specific, where parties can now raise that issue with the High Court of Kenya. The High Court of Kenya is the court of competent jurisdiction to deal with matters arising from arbitration in the first instance. So it doesn't go to any lower court or magistrate court. And when that challenge reaches a court, then ideally what principles are usually employed? The court hasn't really defined specific criteria or a specific criterion for the assessment and establishment as to what comes in terms of challenging arbitrator's authority, simply because the reasons are diverse and circumstances vary from case to case. So the core reasons as to why someone may challenge an arbitrator usually would span across 2 or 3 main core concepts. And those concepts would basically revolve around, first of all, most importantly, impartiality and independence. So courts will usually assess whether if the claim or if the reason for challenge is centered toward a challenge to the neutral's impartiality, or rather their partiality or their independence as an arbitrator, then that's usually central. And why I said case-to-case basis is because those are thresholds that have to be achieved. And if a party is claiming that there is an appearance of impartiality or independence, then that has to be proven on a subjective level. The other core concept that parties usually interrogate is usually competency in procedure or practice, and even substance. And I'll move to substance in a bit. Competency, in this case, at the appointment stage, may not have a lot of flesh to it. But then when you talk about capacity, you're talking about fitness to act. So in instances where parties have specifically prescribed the nature of competency that they want the arbitrator to have in terms of their qualifications, in terms of whether they need to be a specialized arbitrator who has a qualification in a specific area, be it construction or be it architecture. If they want something specific and this is not taken up, then now that feeds into the challenge of the arbitrator or the merits of whomever is presenting that case. To conclude with this question, it's important to note that within our jurisdiction, and I think it replicates in other jurisdictions, the core responsibility of the appointment of arbitrators lay with the party, and the challenge of the arbitrators will initially lay with the party and the tribunal before it goes to the court. So the individuals involved, be specifically the parties, the client, as well as if an institution is involved, then those are the individuals and groups who are primarily responsible for the nature in which the challenge occurs, because at the time it gets to the court, then the court has referenced what the parties have already submitted and what the tribunal has decided. And this will be discussed later, but it is not in the nature of the High Court to micromanage arbitrations and to specifically make decisions on merit. So even at the very beginning, it is not the High Court's duty to reopen and try to make their own assessment. And that is why competence exists, so that it can analyze said decision before it moves to any concrete outcome. And very lastly, so responsibility of institutions, as Dr. Madumera has put it very plainly, it's there is also reference to institutional rules. So these rules usually create basically pre-appointment prerequisites, in that if you're making an appointment and you've made specifications, it is upon that institution to make sure those are fulfilled. If parties have agreed within their contract to do the same thing, it's supposed to be expressly put in. And that knowledge from an institutional and a party and representative perspective is very key. And that is what is employed, at least within our jurisdiction. Thank you very much for that.
Thank you very much, Mr. Karaoke. So I hear you that party autonomy is fully complied with when it comes to the appointment of arbitrators. And when it comes to the challenges of arbitrators, the courts will only typically interfere after the principle of competence has been fully satisfied. So the tribunal would have had the opportunity to pronounce on its own jurisdiction or its own challenge before it then gets to the court. Thank you for that. We'll now turn to the practice in Uganda. Mr. Kadu, we've heard from how it works in Kenya. What are the notable differences in how the courts in Uganda handle arbitrator appointments and challenges?
So the Uganda's scenario for appointing arbitrators cannot be discussed without explaining the current scenario in Uganda, because we're in a very peculiar circumstance. At the end of 2024, there were some amendments to the Arbitration and Conciliation Act. The principle of those amendments being amendment that got rid of the Center for Arbitration and Dispute Resolution in Uganda. Now, why is this important? CADA, as it was called, had almost sole jurisdiction. It was the sole institution in Uganda that had appointing authority to appoint arbitrators. Now, following certain constitutional challenges, the court found that CADA was actually operating outside the law, and consequently, amendments were begun which led to CADA's dissolution. Now, why did I start there? CADA, having appointing authority, used to appoint arbitrators in Uganda. It was the go-to institution. Without CADA, the court has had to step in to give and breathe life, because what practitioners were doing, we were inputting CADA as our dispute resolution appointer in the clauses of the arguments we're entering. So in its absence, many of these contracts are now threadbare with no appointing authority. That would have created a gap which would have made parties end up in litigation. However, the court has had to step in to appoint or to provide for appointing authority in institutions. There are 3 cases. One is Zonghao Overseas versus Attorney General. Now, in this case, the court appointed an international institution in Uganda called ICAMEC, International Center for Arbitration and Mediation in Kampala. Now, the court took a different approach 1 year later in Ambitious Construction versus Uganda National Culture Center, which is the equivalent of our National Museum. In that case, the court appointed another institution, Praxis Conflict Resolution Center. Now, again, the court took another approach, again in the same year, 2023, in Tumo Technical versus China Railway Trade Railway Bureau Group. Now, this time the court appointed an arbitrator. Now, what does this show us? That because of this lacuna that has been left by CADA, the court is having to come up with very creative and new ways that it can interpret these sections or the sections of appointment of the law to give effect to the arbitration. But one thing remains clear, that the courts have said it repeatedly: if you chose to arbitrate, you will arbitrate. CADA, no CADA, we will get you an arbitrator, we'll get you an institution. A matter that has been referred to arbitration by consent of the parties does not end up in litigation because of failure of an institution. I think that speaks to the party autonomy. Now, To go to the challenge, how challenges are handled in Uganda. Now, challenges are provided for under the law, Section 12, and they are mostly on the grounds of impartiality. The most ordinary forms of challenges arise out of impartiality or allegations of impartiality. Now, there are just two very delicate aspects of impartiality and on the timelines that have to be maybe considered by someone, because you have Section 15 of the Arbitration Act, which provides for 15 days for a party to raise a challenge to an arbitrator. And the same act in Section 4 provides for waiver, but it does not give a timeline for a party to raise a waiver complaint. So it's almost a conflicting position that you waive your right to object to an arbitrator. There is no timeline for that, but to raise an objection challenging an appointment, there is a strict timeline of 15 days. So very many times, people who read one section in lieu of the other can end up getting caught up. So perhaps the safe thing to do is to work within the 15 days provided for. So just to summarize how the courts in Uganda have approached challenges to arbitration on instances of impartiality, there are two very critical cases that I think may bolster this discussion. There's a 1999 decision by the principal judge, as he then was, involving Total Energies versus Buramba General. Now, in this case, the applicants, Total, sought to challenge their own appointed arbitrator because they did not agree with his decision. They of course, having gotten the award, they tried to work backwards. Now, in this decision, the court breathed life into Section 4, which is the waiver to object, that if you have taken part in the proceedings, you have been involved in the proceedings from start to finish, you cannot backtrack and claim a waiver of the proceedings on the basis of the decision. So Total lost on an application challenging their own arbitrator on the basis of estoppel. Another interesting decision that was decided by the Commercial Court in 2024, Smile Telecom versus American Tower Corporation. Now, why is this case very important? This case arose out of an arbitration that had been concluded and an award had been issued. Now, where did the impartiality come from? The applicants, after the proceedings, during the proceeding of the arbitration, they found out subsequently that the arbitrator had worked in the law firm that was representing the respondent, American Tower Corporation. So much, and it was not just a relationship of an employer-employee. They went ahead to show that this relationship had continued to subsist even when he left the employment of that law firm. So much so that the arbitrator had written a book just 1 year earlier and dedicated it to the same law firm that was now appearing before him. So on the basis of all these arguments, the respondent was able to make a case that there was impartiality by the arbitrator. He had a very close relationship with the law firm that was representing the respondent, that he, at the time, ought to have recused himself from these proceedings. So what does that show us? Generally, this shows us that in regard to appointment, in Uganda, there has been a gap because that was left by the removal of cadre, but the court has been pragmatic and has tried to come up with solutions that fill this gap. Regarding challenges, the principal sources of challenges to arbitrators have been primarily regarding impartiality, but the courts have been very strict in replying to cases of impartiality and have been reluctant to turn down or to accept challenges on impartiality without critical or sufficient evidence.
Thank you very much, Mr. Kadu. And we've heard a lot about the ground of impartiality and independence as a basis for challenging arbitrators. We've heard this from Mr. Kariuki and now from Mr. Kadu. Dr. Madumere, I want to ask, in the Nigerian parlance, how high is this threshold for proving independence and impartiality of an arbitrator in the context of a challenge? And how often are such challenges on grounds of impartiality and independence? How often are they successful in court?
Thank you very much, Madam Moderator. Now, to answer your question directly, of course, we recognize that arbitration is an adjudicatory process. And because of that fact, arbitration stands on the trust of the parties in the integrity of the process and also the trust of the parties in the integrity of the arbitrator. That is the only way you can sustain the validity of that process. And one fact that allows you, to sustain that validity is the requirement of disclosure. The arbitrator will be required to make disclosures with regards to facts or circumstances likely to raise justifiable doubts as to his independence and impartiality. Now, with regards to the threshold, particularly in Nigeria, what I want to say is that the threshold aligns with international best practices. Why did I say so? Our law in Nigeria mirrors the model law, which is the template across the countries of the world. So that threshold, therefore, aligns with international best practices. And you can see that, reflected in Section 8 of the AMA, Arbitration and Conciliation Act. And it says very clearly that upon being appointed as an arbitrator, the potential arbitrator bears the obligation of disclosing circumstances or facts that are likely to raise justifiable doubts as to his impartiality, and independence. But then, we do not have indications as to what those circumstances might be. And that is why we then fall back to an international framework, which is the IBA guidelines on conflict of interest, which is what parties usually adopt, in international arbitration, as giving us, the instances or the ideas of those circumstances which might lead to, a conflict of interest. But then it's important to also make this point that in determining those circumstances, the test is not subjective. The text is objective. So it is not what the applicant feels. It is what the independent third party, taking a look at the circumstances, will think that, would they then consider that the arbitrator, has the appearance of bias. Keep in mind, it is not bias. It's not actual bias, but apparent bias. And then also you look at then the issue of challenges, and then we can find that in Section 9 of our law. And that law aligns with what the gentleman from Uganda just outlined. Our law says once you want to challenge, you must challenge within 14 days of becoming aware of those circumstances. And then the tribunal has the first option to rule, just like my brother James had mentioned, that happens in Kenya. The tribunal then rules. Last year or so, I was appointed by Madam Chair of our branch here in Nigeria, and I was challenged. I gave a ruling, and then they now challenged my ruling before the appointing authority, which is Madam Chair, and she dismissed their challenge, and then I continued. I think I published the award 6th of December last year. Then another important point also is that our law also clarifies that upon the ruling by the tribunal on the challenge, the other party must either appeal to the High Court or to the appointing authority within 30 days. All of these timelines are just indications of efficiency in arbitration. Now, but with regards to how frequent lawyers, mount challenges, to arbitrators in Nigeria, I must confess I don't have the precise data in my hands. But what I do know, from experience, is that lawyers will be lawyers, and they can challenge arbitrator as a matter of strategy. Some do it for strategic reasons, even though they don't believe in it. For other strategic reasons, which I will not say here because it might be encouraging guerrilla tactics. Some can do it out of whatever reasons that they feel they should do it. But what I do know is that our courts across Africa are becoming a lot more supportive to arbitration, and our courts, and appointing authorities are becoming a lot more supportive. And in several cases, the courts will be too willing to throw away, frivolous challenges and allow arbitration proceedings, to run and to run as should be. Thank you very much, Madam Moderator.
Thank you. Thank you very much, Dr. Madumere. I think what I hear is that the threshold is actually high because you mentioned 3 points. Number one, there has to be justifiable doubts. There has to be circumstances that give rise to justifiable doubt. So it's not just any doubt, but it has to be justifiable. Then you mentioned apparent bias as well. So it has to be clear, very clear that this could lead to bias. And then you said that the test is objective. So a third party or a bystander's test. So it's not just based on what you feel or what you think. So this indicates a high threshold, and with that high threshold, it is indicative that challenges will not typically be successful because you have to reach a very high test in order to get a successful challenge. Thank you for that. I'll turn to Ghana now, Mr. Lati. We've heard from the other jurisdictions how challenges are handled. How frequently are arbitrator challenges successful in Ghana compared to these other jurisdictions?
Thank you very much, Chizaram. I would start off from the point where Dr. Madumere ended. And if you ask about how frequent, challenges are successful, it would connote that there is some kind of empirical data that you have to ascertain the number of challenges that are filed and how successful they are. To answer this question, first of all, we need to look at the statutory framework for presenting a challenge, right? Under the Ghana's ADR Act, Section 16 of the Act, under subsection 3 provides that unless the arbitrator whose appointment is challenged withdraws from the arbitration or other party to the arbitration agrees to the challenge, the arbitral tribunal shall decide on the challenge. So what that presupposes is that very often it is the arbitral tribunal that decides on the challenge. And because arbitration is confidential, you often would not get the opportunity to get information on how frequent, these applications are brought, and then secondly, how successful they are. But I will speak from my experience in the number of arbitrations that I have been involved in. I think that so long as parties are able to demonstrate, that there's been reasonable cause to, infer that the arbitrator is not independent and impartial, once this is made before the tribunal, there is 2 things either happen. It's either the arbitrator recuses himself or the tribunal rules agreeing to the challenge. And we had an experience in an arbitration where we had an arbitration against a state entity, and both parties appointed their party-appointed arbitrator, and the chairman of the arbitrator, who was appointed by the party-nominated arbitrators, was somebody who had been nominated for appointment to the Supreme Court, right? And again, the threshold is similar to that was raised by Dr. Madumere. So there should be a disclosure, first of all, of facts that you think would raise reasonable doubts as to your impartiality. Now, this chairman did not raise this facts before the tribunal and before the parties that, even though it's common knowledge that he had been appointed to the Supreme Court or considered for nomination to the Supreme Court, he did not disclose this. But aside from this, there was also a very crucial factor. The same arbitrator had been nominated by the government of Ghana in other international arbitrations on 2 consecutive occasions over the past 3 years. Again, this wasn't something that he disclosed to the parties. And so we filed a challenge. And the procedure is also aligned with that of Uganda. You have to file the challenge within 15 days of becoming aware. We filed the challenge, and the tribunal did not even have to decide on it. The arbitrator, upon seeing the challenge, sent a response to say that, well, he never thought that this was circumstances that would raise reasonable doubt as to his impartiality or his independence. And so under the circumstances, he will recuse himself. Interestingly, in another international arbitration, and this award is out there, I think Cassius Mining versus the Republic of Ghana, the same arbitrator, right, was also challenged around the same factual circumstances on the basis that he did not disclose that he had been nominated for appointment to the Supreme Court. So just to answer your question, I would say that because I do not have data on how frequent these challenges are successful, I would limit myself to my experiences, and I will say that very often, if you are able to objectively demonstrate that they are objective reasons for suspecting that this arbitrator or coming to the conclusion that this arbitrator cannot be impartial or independent, you're likely to be successful. Thank you very much.
Thank you very much, Mr. Lati. And I know we've spoken about disclosure of information or any fact that is likely to give rise to reasonable or justifiable doubt as to an arbitrator's independence or impartiality. But just hearing the discussion makes me think, would the failure to disclose in itself be a basis for challenge, or does it would one say that it gives rise to justifiable doubts as to the arbitrator's independence and impartiality, that singular act of failure to disclose? But no, it's not a question that I would want you to answer now. We can take that during the Q&A session. We'll just move on to the next issue, which is the overall conduct of arbitration proceedings. And on that, I would ask Mr. Kadu from Uganda, are there any specific reforms in Uganda that Uganda has adopted to align the conduct of arbitration with international best practices and essentially promote efficient resolution of disputes?
So just to answer the question off the cuff, no, not yet. However, that's not to dampen the answer entirely. The Uganda Arbitration Act has been under review and amendment for the past 3 years. Unfortunately, the reviews and amendments that are happening piecemeal, are happening slowly and sporadically. Now, there have been some reforms, as I've already alluded to, like CADA, but many of the reforms have happened in the rules and within the institutional arrangement rather than within the legal framework or strict within the confines of the Arbitration and Conciliation Act. So in that regard, the International Center for Arbitration and Mediation in Kampala have come up with rules that have incorporated things such as online hearings, have incorporated things such as the use of tribunal secretaries, have incorporated new rules such as online filing systems. They can now have an entire arbitration handled online. We have things that are new in the Ugandan jurisdiction, such as a no documents arbitration, which are now provided for in the rules. Emergency arbitration is also now provided for in the rules. So there has been a lot of external force. There has been a lot of external use of an outside legal or strictly within the framework of the within the framework of the Act. But the rules have been very progressive, particularly the ICAMEC rules, which are what very many of the arbitrations in Uganda are currently being conducted under. However, besides the ICAMEC rules, there are the CADA arbitration rules, which again, because of the very many problems that CADA is facing or has faced recently, have not been relied on as much as perhaps they would want to be relied on. However, the CADA arbitration rules in Uganda are a replica of the UNICITRO model law, and many of the provisions follow the UNICITRO model law. So in that regard, Uganda is up to date with the rest of the world insofar as we adopt the UNICITRO model law, which we apply in Uganda as the CADA arbitration rules. So I've discussed CADA, I've discussed ICAMEC. What about the court? So the courts have also done some sort of reform in their practice. They have also gone out of the way to make some practical changes to align with what the rest of the world is doing. For example, I'll give you a scenario on the question of costs. In Uganda today, I think as many other Commonwealth jurisdictions and jurisdictions around the world, the questions of costs are managed by the law. Unfortunately, that is not the case for costs in arbitration. So, whereas there are costs in litigation provided for, and even the ICAMEC rules provide for costs for the arbitrator, there is no hard and fast rule of costs for counsel in the arbitration. So the courts faced a scenario where they had to make a determination on the issue of costs in arbitration. And the case of Pearl Marina versus Rocco Construction, it was decided in 2024. The Commercial Division of Uganda said that whereas the determination of costs can be borrowed from the litigation side. Here it falls to the parties because this is a party-led dispute resolution mechanism, and this is private dispute resolution. And in the absence of any hard and fast rules, it comes back to the parties to determine the issue and the question of costs. So in that regard, the courts, and of course, I also allude to the decisions where they've had to come and step in to fill in the void that was left by CADA or the void that was left by the absence of a statutorily backed arbitration center. So the courts have also gone out of their way to take part in this, you can call it judicial activism, to breathe life into arbitration, to breathe life into arbitration agreements. And to that end, there has been a multi-pronged approach to try and bring Uganda up to speed with the world in terms of jurisdiction and in terms of handling matters in a cost-efficient and efficient manner in arbitration. However, these are not backed by the law. But do not despair, our act is in the amendment process, and as soon as we have a new parliament, it will be the first that we table. So also we have an ADR policy, maybe just to summarize this. There's also a national ADR policy that is also in the works. It is being done with the support from the United States government, Pepperdine University, Justice Law Order Sector in Uganda, and they are just putting together this national ADR policy that provides for alternative dispute resolution in the different sectors of Uganda, beyond arbitration, but mediation, conciliation, third-party determination, and other forms of ADR. So the ADR policy will supplement on some of the reforms that we expect with the amendment of the Arbitration and Conciliation Act. Thank you.
Thank you very much. Thank you very much, Mr. Kadu. So we've heard from Uganda that in terms of legislative acts, not much progress has been made, but the courts are generally supportive. There's an arbitration policy, and the rules have tried to develop to keep up with international best practices. Now, turning to Nigeria, Dr. Madumere, are there developments in Nigeria that have translated to measurable improvements in efficiency and the cost of resolving disputes? Or are the developments that have gone on just largely aspirational?
Okay, thank you very much, Madam Moderator. My direct answer to your question would be to say yes. And I will demonstrate that by looking at some sections within our law that have shown a lot of innovation and development that and practicality of those provisions have impacted in the way arbitration is conducted in Nigeria. For instance, if you look at Section 1.1 of our Arbitration Act, it clarifies that the object of arbitration remains to be to promote resolution by an impartial tribunal without unnecessary delay and unnecessary expenses. In other words, efficiency of the process is the object, the timeliness is the object, and then it must be within budget for the parties. And also Section 7 of the same law with regards to appointment. Before 2023, the default number under our law used to be 3. In other words, if parties don't agree in the agreement as to the number, the default number becomes 3. But with the 2023 law, default number is now 1. So unless you specify in your agreement the number of arbitrators, otherwise the default number becomes 1. And also, under the previous law, the appointing authority was just restricted to courts, and the court and recourse to that mechanism was a judicial process. But under the new law, the court is defined as the chief judge of any of those states sitting in chambers. In other words, it's no longer a judicial function, but just an administrative function. So all you need to do to get the court to appoint, just a simple letter to the chief judge of any of those states, asking them to appoint an arbitrator for you, the same way you can write to the chair of our CIR or chair of any other arbitration institution, and the appointment will be made. Also, before the new law, there was no clear provision on consolidation of arbitration. But with the new law, under Section 39, there is a clear provision for consolidation. In other words, you could bring related arbitration together, and then, conduct them under one arbitrator, and that reduces costs and ensures efficiency. Also, there's also a clear provision also for joinder. Under our law now, you could actually apply for joinder of people into the arbitration. That also reduces costs and ensures efficiency. Then also, there is also Section 62, which talks about third-party funding. It is now a provision in our law, and I'm aware, of one or two instances where people have utilized it, to bring in third-party funders. Of course, the value of that is that it gives access to justice. Parties who are unable to fund their litigation can then get a third party to fund it, upon being assessed and being accepted. And overall, our law allows the tribunal what I call procedural sovereignty, because under Section 30, it says the tribunal is at liberty to conduct the process in a way it deems appropriate. That is why the knowledge of the arbitrator is paramount. Arbitrator must understand the procedural powers that he carries to driving that process in a way that is efficient and effective. So overall, my answer is yes, our law is up to speed. Our law has made very useful innovations, and they are beginning to reflect in the quality of arbitral process in Nigeria. Thank you very much, Madam Moderator.
Thank you very much, Dr. Madumere. That was very insightful. You're welcome. I will now turn to Mr. Kariuki. In Kenya, are there developments to the conduct of arbitration that align with international best practices? And is there judicial support for such developments?
Thank you for that, Madam Moderator. So to avoid duplicating what has already been said, from the Kenyan perspective, I would say we are very up-to-date, emphasis on only on the matters that have been persistent issues over time. When you discuss time and costs in arbitration, it takes me back to how we are introduced to arbitration or ADR from an academic perspective. And for those who've been in any class, ADR or arbitration, you'll often hear that arbitration is cheaper and more cost-effective. So we are coming into this practice with the premise to save on time and costs. And this is legislated within our law. And our Arbitration Act of 1995, Section 19A, talks about, as very related to what Dr. Madumere said, that it is upon the parties. The parties have a duty to promote the proper and expeditious proceedings within the conduct of the arbitration. So it's not just upon an arbitrator or upon the neutral to ensure that time and costs are managed. It's also a party obligation. Now, I'll touch on three perspectives. First, similar to what Kadu has pointed out, we have had, there is more institutional fleshing out on procedural provisions on time and costs in particular. In Kenya, not to give any favor, but we have two prominent institutions. And one of them is the Chartered Institute of Arbitrators. It's been here for quite a bit of time, since the 1980s. And more recently, we've had the Nairobi Center for International Arbitration, which came into life around 2015. So a majority of contracts which have arbitration clauses will have, ideally, either it's a multi-tiered process. So when you talk about time, as Dr. Madumere has pointed out, when it comes to what parties have agreed in terms of what precedes arbitration, and even the manner in which appointment of arbitrators is done, the more arbitrators, the more time it takes, because there's the appointment of each, and depending on the nature of the clause, they have to appoint the third arbitrator or any other provision that comes into play. And if one arbitrator is brought into the picture, then it simplifies it from a time and cost perspective. And when you talk about, even before I move to courts, we need to look at all perspectives when it comes to time and cost management. And there are three primary perspectives, of course, the two being parties and the tribunal. And particularly regarding costs, when we talk about you have to discuss which type of costs, because we have the costs to the tribunal, we have the costs to the party. And cumulatively, even when it comes to the assessment of the cost of the tribunal, it's important. And that is why the preliminary meeting is very key in many arbitrations, because it's an opportunity for parties, regardless of what is coded in the arbitration agreement, to jointly agree on other aspects that may either lessen the time it may take or lessen the costs. So what I mean by this is, as long as there is a realization, because usually when a matter comes up as a dispute, it's a contract that was signed very many years ago. And at that point in time, you do not anticipate the quantum of the value. So for example, if the quantum does not necessitate the appointment of 3 arbitrators, we have, as actually everyone here has talked about, lawyers will be lawyers and everyone has their own camps and they'll stick to the lane. But then the realization is coming together to change substantively what the agreement may say by agreement. And instead of 3 as it's provided, you appoint 1 arbitrator. That makes a world's difference. And further, when you talk about costs, particularly within the realm of the arbitration as it's proceeding, there is also, it's very important that, Kenya has also factored in the mitigatory measures, at least from an institutional standpoint. Both NCIA and CIAB have provided for a number of things that Kadu mentioned in terms of, expedited arbitration, documents only, proceedings. You talk about fast-track arbitrations, emergency arbitrations. All those provisions are in place from a regulatory perspective. And most of the issues may come up from ad hoc appointments where no particular institution or regulation comes into play unless the parties accede to them voluntarily. So leading on to costs, now when it comes to the courts. The courts, as I mentioned in the first presentation that I had, the courts do not or will not actively micromanage. And we'll explain this further on. The courts are very, very conscious of the independent and parallel nature of arbitration proceedings and hesitant to interfere with merits. However, you will find a few exceptions. I'm going to reference 2 cases. One, it's still currently ongoing, so I may not reference it, but it's too interesting to pass. There was an arbitrator who, in a very unusual way, applied to court following the issuance of an award. The arbitrator, on his own volition, made an application to court to enforce the award and so that his costs are settled. So the arbitrator is both the applicant, or rather the arbitrator is the applicant as opposed to one of the parties moving the court to either enforce or set aside. And the arbitrator is not only asking for their own costs in terms of pending fees not paid by one party, but fees from the other side of, or rather either the claimant or the respondent, those who did not pay. So in terms of the unusualness of the application, the court basically looked at this application and noticed that the arbitrator's costs far exceed the quantum in dispute and the costs being issued. So in essence, it's almost doubling the nature of the dispute that was presented before the arbitrator. And if it wasn't, for the impropriety of procedural impropriety of the application and how it was presented, then that wasn't interrogated quite deeply. However, in a subsequent case that I can reference, Ongata Works versus Tatu City, this is a recent case. I think it was 2024. So in this case, the arbitral tribunal issued an award on costs that exceeded the damages issued within the substance of the dispute. And the court was of the view, contrary to the case Mr. Kadu referenced, the court was of the view that the award, or rather the amount of costs is issued is astronomically high, and that goes against Kenyan public policy. So it was a very controversial decision, because I think we'll touch on that public policy issue, because it's a whole issue in itself. So in a nutshell, in as much as the courts will more or less—
Thank you very much, Mr. Kariuki.
I just conclude, in as much as courts will have an opportunity
Can I still be heard?
to get those issues, then they will not really delve into all the specifics. And it's highly a party obligation, or a party duty and a tribunal duty to manage and mitigate costs in a tribunal. I don't know if I exceeded my time.
Thank you very much, Mr. Kariuki. Yes, we did spill over we use more time than we ought to, but it's fine. It was a very thorough expository into judicial attitudes of the courts towards the conduct of arbitration. Because we have very limited time left, we'll just go on to the next issue, which is the enforcement of awards, the enforcement and setting aside of arbitration awards. And we will have— I would urge all speakers to keep their answers very brief, a lot less time than we initially anticipated, so that we can have some time for Q&A. So the first question is going to go to Mr. Kariuki, and in just 1 minute, are there— or I would ask the question this way: how clear and predictable is the legal framework for the enforcement and recognition of arbitration awards in Kenya? And if there is— what is just one common challenge encountered in enforcement proceedings? Just one common challenge.
Thank you very much. I've noticed the emphasis on time. I am most obliged. So from a general perspective, Kenya, for quite some time, the main issue has been inconsistency in judicial decisions with respect to the breadth of what could be considered the grounds for setting aside and the enforcement. So I won't dwell so much on enforcement, because that's a subsequent to the setting aside procedure. However, it's very coded, or rather it's clearly coded in law. We have a specific criterion under Section 35 of our Arbitration Act, as well as Section 36 of our Arbitration Act with respect to setting aside and enforcement, respectively. However, the nuance is, and I know this will be a common aspect with what we're all going to discuss, is the aspect of public policy. So within Section 35 of our Arbitration Act, everything is clear-cut and very specific. And there's only one omnibus provision that parties have taken advantage of, because there is an inherent habit of parties believing that the enforcement and setting aside procedure is furtherance of arbitration, regardless of whether there are substantive reasons to continue or otherwise. So, very briefly, the Kenyan position for quite some time has been inconsistent because of the nature of court decisions. However, there was a landmark decision in 2019 by the reference Nutu Agrovet versus Airtel Network Kenya, where the threshold that was set was that for, or rather, the avenue for an appeal to the High Court, again, the primary court of first instance jurisdiction for all arbitration matters. So the only avenue where public policy may be allowed in terms of opening is where the High Court has stepped outside the ground set out, again, in Section 35, and made a decision so grave or manifestly wrong, which has completely closed the doors to justice. And I could go on into the interpretations of what public policy means, but then what that did is the decision from the arbitrator has to be outside of Section 35 in the first instance, and so grave such that it defeats justice in a manner of speaking. So that doesn't necessarily close the door when it comes to enforcement and setting aside, and we still see many applications coming in. However, it has narrowed down the extent of abuse of the public policy aspect.
Yeah.
And I think one of the important aspects, or one of the important developments in enforcement and setting aside is the propagation of arbitration knowledge within the judiciary. What the institutions in Kenya have done is that they've actively set up trainings in which judges are now being made specifically privy to the nature of arbitration, because there's the assumption that they will understand. But then the attitude in Kenya has been positive, because there has been a significant increase in that education, and judges are now able to interrogate where parties are specifically abusing the public policy avenue, and where they're exceeding the authority beyond arbitration, which ought to come to an end. So in sum, we are very cognizant of our landscape in terms of enforcement, and setting aside has been curbed only to specific issues that touch on the merits of the decision made by the arbitrator. Thank you very much.
Thank you. Thank you very much, Mr. Karaoke. Still on the issue of enforcement, and particularly public policy that Mr. Karaoke has mentioned, I want to ask Mr. Lati, in Ghana, how often is this challenge on the basis of public policy or due process violation raised, and are they frequently successful? Please, in just 1 minute, if you can give us an answer. Thank you.
Thank you very much, Chizaram. I'll try to wrap this up in 1 minute if possible. But I'd say that you often tend to see enforcement being resisted more on the grounds of due process than public policy. So for due process, what we often do see is that the arbitrator has either raised or canvassed an issue and determined that issue when the parties themselves did not raise this issue before the tribunal. And there are a number of cases and decisions on that. I wouldn't want to hold forth on that. But in respect of public policy, I would say that we rarely see awards being resisted on grounds of public policy. As a matter of fact, in the court record, there are very minute, I wouldn't say minute, but I don't think there are a number of cases on the issue of public policy. And I'll say that the reason being this, very often you find that international investors would not want to enforce an arbitral award against the state within Ghana. Obviously, because they would see that would be an avenue for the state to raise the issue of public policy. One particular instance is the case of Balkan Energy versus the Republic of Ghana. This was a case where there was an agreement for the refurbishment of certain thermal plants in Ghana some years ago, and the argument of the state was that agreement was an international business transaction and so ought to have laid before Parliament for parliamentary approval. So they sought to bring an anti-suit injunction to resist, the arbitral tribunal from hearing the matter. The arbitral tribunal went on to make a determination, and then there was an award. So clearly you would see that the whole issue with respect to the fact that arbitration stemmed from an agreement which ought to have been laid before Parliament, being a constitutional issue, raised a potential for a resistance of the award on the basis of public policy. And so the investors, when it was time to enforce the award, did not enforce it in Ghana, but went to the United States. But guess what? Ghana relied on the defense of public policy to say that the enforcement of the award was against the public policy of the United States. This was refused by the court in the United States. So clearly you would have seen that if they had tried to enforce the award in Ghana, that would have been, the approach of the Attorney General. So we often hardly see the issue of public policy being raised as an issue, because you don't find investors enforcing awards in Ghana, but what we often do see is the issue about due process, particularly in respect of domestic arbitrations being enforced, domestic arbitration awards being enforced in the country. So I hope I've been able to do this briefly. Thank you.
Thank you. Thank you very much, Mr. Lati. So indeed, public policy is not frequently raised in Ghana. Mr. Kadu, in Uganda, what would you say is the part of the enforcement process that tends to generate the most difficulty?
Well, for the case of Uganda, unfortunately, we are also facing the similar problem of public policy, which has now become a panacea of sorts. It's an all-solving problem. Anyone who wants to challenge an award, they first go to his public policy. So we are seeing a new rise of cases that are trying to challenge awards on public policy. However, beyond public policy, there are also there's been difficulty in cross-border enforcement. Cross-border enforcement, and there are two cases that anyone who's interested can look for after. Sani versus Bemuga. Sani versus Bemuga was trying to enforce an award from Hong Kong International Arbitration Center. And there was a challenge that was raised on public policy issues, lack of a fair hearing, all of which the court rejected. Also in that case, the court rejected the presentation of a counterclaim which had not been considered at hearing. So that case shows you the difficulty. The second case which can point you to the difficulty first in enforcement is Housing Finance Company versus Kampala International University. Now, why is this important? Because the applicant got a facility from a financing institution in Kenya, which in arbitration then wanted to enforce in Uganda. Now, they raised the public policy argument when they came to enforce in Uganda, arguing that they've already begun enforcement proceedings in Kenya. However, that argument was also rejected. So for the case of Uganda, it's been a balanced bag of seeds, but generally public policy is on the rise, I have to say, and everybody is running towards the direction of public policy. However, we've had also some instances of the arbitrator exceeding his mandate or challenges on a fair hearing, which have also made enforcement difficult in Uganda in some instances.
Thank you, Mr. Kadu. So public policy is an issue in both Uganda and in Kenya, but in Ghana it's less of an issue. We are going to turn away from public policy and other grounds for enforcing or challenging the enforcement of an arbitration award and focus now on the efficiency of enforcement proceedings. So, Dr. Madumere, in Nigeria, how would you describe the process for enforcement? Is it more efficient? Is it efficient or is it prone to delay?
Okay, thank you very much, Madam Moderator. My contribution will be two prone. First one, the legislative frameworks, and then secondly, the support of the courts. Now, from the legislative side of things, of course, we recognize that Nigeria is a member state to the New York Convention. And what that means is that apart from being a member state, we've also domesticated it in our law. So which means the ground for challenge reflects entirely Article 5 of New York Convention, which means you couldn't challenge based on substantive error, but just on procedural infractions. Those are the basis for which challenges could be made. And then before now, the common ground for challenge in Nigeria used to be misconduct because it was an omnibus ground which people could just fit into. But our law now has clarified the grounds for challenge and aligns properly with the New York Convention. But what you then see is an emphasis on public, we are in court. I mean, my law firm is in court at the moment trying to set aside an award before the High Court. And one of the grounds we raised is the ground of public policy. And the way we couched it is when there's a misplacement of burden of proof on the wrong party, that of course challenges the adjudicatory, public policy of courts. And that for us means that's an infraction on public policy. Now, with regards to the courts, which is where the real problem is, our courts are gradually buying into the merits and the advantage of arbitration, are becoming a lot more supportive. But then a lot more needs, it has to be done also to get our courts buy into, the arbitral process. Like I ask people always, the case of PNID, for instance, if that case was filed or argued before a court in Africa, is there a possibility of resolving it within the timeline it was resolved? Is there a possibility of having the same outcome that we had? Those are things that we need to, to look at. So, of course, we are making progress, but then a lot more needs to be done. And then also the issue of different layers of challenge, of appeal. For instance, here in Nigeria, you challenge at the High Court, you could appeal to the Court of Appeal, and you could appeal to the Supreme Court. If you're lucky at the High Court, you get a judgment in 3 years. If you're lucky at the Court of Appeal,
Yeah.
you get it very fast in 5 years. If you're lucky at the Supreme Court, if it comes out in 10 years, you'll be very lucky. But I know we are still better than Ghana anyway. But very, very useful introduction that we've had recently is what we have in Schedule 3 of our law, which is called the Arbitration Proceedings Rules of 2020. If you look at Rule 12 of that law, it says that if there is an appeal against an arbitral outcome, that the first hearing must not be later than 6 months after the record of proceedings, were filed. So I believe that with time and implementation of that law, a lot more improvement with regards to turnaround time on appeals will be, experienced here in Nigeria. So in all, Madam Moderator, I think there's improvement in Nigeria. Thank you.
Okay. Thank you very much. Thank you very much to all our speakers. I know that there has been a lot of issues, and if there was more time, we would have gone through and debated. We've heard about the conduct of arbitration in various jurisdictions, issue of appointment. We've also indeed touched on how our national courts come in all these various aspects of arbitration. And I think the message that is being passed is that there is some form of support, or our courts across various jurisdictions are increasingly becoming supportive of arbitration, even though that there's still progress to be made in that regard. We would have to end our discussions here to give a little time for Q&A and then finalize the session. So at this juncture, I would like to say thank you again to all our speakers for your insightful contributions. I'm sure that our audience got a lot out of it. Thank you. So we're going now to Q&A. I'm going to check the chats now if there have been any questions. I mean, I can't see any questions here, but if you have any questions, feel free to just share, raise your hand. I believe that you'll be given access to make your contribution.
I can see a comment.
Is there any question? Okay.
Kenyan Courts by Michael Afuye in the chat.
Michael Afuye. I mean, I can't see it. Mr. Kariuki, if you can see it and read it out, that would be very helpful.
All right.
Okay, I see it now. I see it now. But I'm happy to read it. So Michael Afuye says, do Kenyan courts have a liberal or strict approach to a public policy ground in setting aside awards? So I think Mr. Kariuki can take that.
All right. So ever since 2019, ever since the position was centralized to basically limit the nature in which public policy has been interpreted, because one of our cases referred to it a very long time ago as an unruly horse. So essentially, whether courts take a strict approach to public policy, I would say Kenya takes quite a strict approach in its assessment of public policy, or rather where claims for setting aside have been brought under public policy. However, that does not prevent parties and counsel from basically raising anything under public policy. So as I mentioned in one of my, or previously, the last time I spoke, what has generally improved and what has moved this to a strict approach is the sensitization of the nature of arbitration, especially within the judiciary. We have many members of our judiciary, all the way to the Supreme Court, who are members of the Chartered Institute Fellows, etc., and who are aware of arbitral practice. So to answer his question, yes, it is more of a strict approach. And the case that I referenced on Tatu City and Ongata Works, personally, the interpretation of that case is more of an exception, because the reason I call it controversial is because cost is a merit issue. Parties have exchanged submissions on the same, and basically to say that it's astronomical without any underlying justification may in itself be seen to be interjecting into the merits. So strict approach. And of course, there'll be instances where courts have deviated and may try to inject, their own assessment. But then the general approach is arbitration is its own thing, and the courts uphold and respect arbitration and only intervene when it has gone beyond its parameters.
Thank you very much, Mr. Kariuki. We will take just 2 other questions so we can end the session. I see a hand up, and then we have another question in the chat. So, Mr. Shola Adegomire, your hand is up. Please feel free to turn on your microphone and ask your question.
That's the chair. That's the chair of the branch.
That's the branch chair.
Thank you
I'm
very
so
much.
sorry.
No, it's okay.
Please
Thank you
forgive me. I didn't recognize the name immediately I saw it.
You're so forgiven, and forgive me. I tried to join at the beginning, but I just kept falling on and off the platform until I then went to register, and somehow that new link was much more stable. I just want to say that this has been a very, very interesting webinar, and it's so wonderful bringing at least four African countries together and, learning the differences. But it seems as if there are more similarities than differences. And I think we need more of this, because already I'm looking forward to appointments in Kenya, in Uganda, in Ghana. Thank you very much, Mr. Latte. Greetings to Uncle Sam in Ghana, and thank you, James. Greetings to Papa as well, and Mr. Kadu. We're going to be seeing you very soon in Zambia. Or in Uganda, but I think we'll all see during the program in Zambia, hopefully. And of course, our trustee, before our trustee for Africa, but now he's gone beyond that. He's our second in command trustee for CIAB, Dr. Badibere. Thank you very much. But I find this very interesting, and all the things that we have talked about. I wish there was a way, we could even harmonize our laws even more. Uganda is getting ready, changing. Nigeria, we did one big swoop, even though it took a while. But I think that there are things we can learn from each other, and maybe we can work together. Some of us have been involved in other countries, their laws and so on. And I think it's something we need to think of, how we can work together, maybe through webinars like this, to harmonize our law. So it becomes easier every day to move from one jurisdiction to the other to practice, and being all Africans, I think it's very important that we try to open up our space for ourselves as well, because it's important that I don't want to say that even the arbitration in Africa, a lot of people are taking it out. I think that we have to make provisions that will enable us to do more within our space. And I think webinars like this will help us. We get to know ourselves. I've already met some people online. I was happy to see some people say, they are LinkedIn, connect with me on LinkedIn and so on. And I think this will help us all to do more. Thank you very much. For me, this has been very enlightening. Thank you, Abisoye, for putting this together, and Chisom for moderating so well. Well, I'm so glad to be here, and I look forward to the next one. Thank you very much.
What about the moderator? Is she still here?
Thank you very much. I'm still here. I'm still very much here. Can I be heard?
Yes, we can hear you.
Great. Thank you very much to our able chair. Apologies for the error in the first time. I think that would be all. We still have some more questions in the chat, but my apologies, for want of time, we cannot take any more questions. I know I had said we would take 3 questions, but I'm looking at the time and I know we are way past our time. So you feel free to reach out to any of the speakers if you have any further questions on LinkedIn, and I'm very sure that they will be happy to answer your questions. Thank you so much for joining us. We've had very impressive joining or attendance, and you've stayed through the whole process. We are grateful, and I'm sure that you have learned a thing or two from all the jurisdictions that have contributed their insights. At this point, I'll hand over back to our YMG chair for any final remarks and closing of the session. Thank you.
Madam Chair, before you close, could you please indulge me a minute? The gentleman,
Sure.
Gentleman, somebody asked a question that which should be the hub for arbitration in Africa. Now, for me, if I was to vote by secret ballot, my vote would go to Kenya. But if you want me to speak here as a Nigerian, then I'll say Nigeria. and then somebody asked about Uganda and sit. The question, that man from Uganda, that's Mr. Musoko, it appears is from the opposition. And that's a political question. So I don't think anybody wants to answer that question. Thank you very much for having me. Enjoy your day. Bye-bye.
Thank you so much.
Thank you very much, Mr. Madumere, Dr. Madumere.
So we'll have the General Secretary Kinovo to give the vote of thanks.
Thank you, YMG Chair, Nigeria. And my job is very simple. I'd like to thank all our panelists and our moderator for a really exhilarating and exciting session. As the chair said, is glad to have people from across Africa, from Ghana, Uganda, Kenya, and of course, Nigeria, giving their perspective on the procedure, the enforcement, and even challenges to awards. This is the kind of session that YMG was built to do, and we're just really grateful for your insights. And we hope that the next time we call upon you, you will always answer our call and come again to give us the knowledge and understanding of the arbitral process. To all our everyone that joined in today, we also say thank you. Thank you for being engaged. Thank you for asking questions and staying throughout the process. Please, we have in the chat box the LinkedIn links to all our panelists and our moderators. You can follow them and you can obviously interact with them on LinkedIn and ask your questions. Thank you, everyone, and have a lovely afternoon.
Thank you very much. Bye-bye.
Bye.
Thank you. Bye-bye.
Bye.
Thank you for organizing. Have a good day.